When one plans to undertake a new project or task, they generally seek out one thing before they really get started: knowledge. People don't buy a house without taking a look inside of it first, or seeing what the price is, or looking around it. And people don't climb onto a plane and tell the pilot to take them anywhere when they decide to go on a vacation. Instead, what they do is they do quite a bit of research and gain some knowledge into a situation before they actually act, and sometimes sometimes trivial decisions, sometimes major ones. And Congress is no different. In order to effectively legislate something, Congress has to have substantial knowledge on the fact. They can't effectively regulate something that they know nothing about, as it will end badly and effectively do nothing. Now, in order to gain knowledge, Congress holds investigations. According to the Senate website, the process is the chamber that's conducting the investigations appoints a special committee who does a probe into the subject matter, and what they do is they can subpoena witnesses, subpoena documents, and various other things in order to gain knowledge on the matter. Once the investigation is over, they report back to their chamber, and the legislative process begins. Now, the controversy surrounding investigations is not the fact that investigations happen. They've been going on since 1792 and continue today. In fact, what the basis for investigations comes not from the Constitution explicitly. It's not an enumerated power. It's instead an implied power coming from the Necessary and Proper Clause. In the Necessary and Proper Clause, Congress must make laws that allow it to execute its other powers. In this case, its power is to legislate, which is very much allowed to do. And in order to legislate, they have to have knowledge, and investigations are the way to go about and get that knowledge. So in this case, it's been determined that congressional investigations are in fact constitutional themselves, and a lot of people regard them to be some of Congress's most powerful powers, to put it bluntly. What is controversial about these investigations are two things. One, is there a limit on what they can investigate? Is what they can investigate basically boundless? And number two, what are the rights of witnesses who are called before them? Can Congress compel them to answer under threat of contempt? Do they have to produce documents? And for a while, there were no answers to these questions until the first case, in 1881, was Kilbourne v. Thompson, which the Kilbourne was a banker who refused to produce documents to a House committee hearing, and when he did not, he was held in contempt. Upon his release, he sued Congress, and claiming they had no right to investigate his private affairs into something they ultimately weren't going to legislate. The Supreme Court agreed, and from this, 4 tenets came to hold congressional investigations. Number one, they cannot investigate things that are that have to do with the executive powers or court powers. Number two, investigations have to be something they're planning on legislating. They can't investigate just anything for any purpose. It has to be something they're going to legislate. 3, the thing they're planning on legislating obviously has to be something they can legislate for. And 4, if Congress is investigating a witness's private matters, it has to be on something they plan on legislating. They cannot just investigate private matters for no reason whatsoever. So what this case did was it kind of was a very narrow ruling on what Congress could do in their investigations, but then a few years later, in McGrain v. Doherty, it blew it back open again. In this case, it's basically the same thing. Doherty was a bank official who refused to come before Congress and to testify and produce documents. And when he was held in contempt for it, he sued. But in this case, they held that what Congress was planning on legislating was in fact constitutional, and his contempt was upheld. So what this did was it basically took Kilbourne v. Thompson and kind of threw it out the window by saying they can't investigate private matters like that, as it was something they were planning on legislating, when it was ultimately kind of the same facts. But 2 important things came out of McGrain v. Doherty. 1, Congress can compel witnesses to answer under threat of contempt, as the courts noted that people tend not to do things unless they have some sort of motivation, in this case a punishment. And number 2, something very important, was again, they reiterated, if the questions that are posed to witnesses are not constitutional and have no pertinency to the investigation, they do not have to be answered by the witness. And that is very important in the two main cases I plan on talking about, Watkins v. United States and Barenblatt v. United States. Now, fast forward to the 1940s and 50s. What happened during that time was communism communism was around. People were afraid that it was invading the United States, and the House created the House Un-American Activities Committee. And what that did was that investigated communist activities inside the United States in order to root it out and get rid of it. In this case, Watkins was pointed out to be a Communist Party member by two other witnesses, and when he was called to testify before the committee, he answered a few questions about his involvement, but refused to answer other questions about other people's involvement that were not Communist Party members anymore. He was held in contempt by the committee, for not answering the questions. When he sued, the Supreme Court, in a 6-1 decision, held with him that these private matters had nothing to do with the legislative process they were at hand and had no pertinency to the investigation at all. So, in this decision, which I would like to point out is very much a legal one, as it followed the precedent set by Kilbourne A. Thompson and McGrane v. Doherty in saying that they don't have to answer questions that aren't pertinent, and it's also not strategic and not attitudinal. It's not attitudinal for the fact that it was a 6-1 decision showing a great majority of justices who had different viewpoints, and was not strategic, as no justices had long-term views and policy, and did not protect the Supreme Court as an institution. Now, after this decision came out on a day known as Red Monday, when a lot of negative liberal decisions came out, the public and Congress were furious. There was a lot of backlash towards the Supreme Court, and Congress, there was even talk of stripping jurisdiction away from the courts. The courts, in response, just 2 years later, in Barenblatt v. United States, largely the same facts. Barenblatt was another man. Lloyd Barenblatt was called before the committee to testify on his communist activities and other people's. When he refused to answer the questions, he was held in contempt. This time, however, in a 5-4 decision, the Supreme Court upheld his conviction, stating that the need to legislate this and investigate the Communist Party was greater than the needs for his individual rights. And so he was held in contempt. That was upheld. But this decision is largely a strategic one. It was done to protect the Supreme Court from backlash again and from losing their jurisdiction. It wasn't legal, as they didn't follow precedent set just 2 years before, and it wasn't attitudinal, as there were largely the same justices on there. Only one was switched, and they had the same viewpoint. Now, what does this mean going forward? It basically gives Congress unlimited power when they're investigating. The precedents were overturned, and it's basically right back to where they started. They can investigate just about anything they want, and their power is unlimited when considering it. The only thing that the only court case that's very relevant since then is Gibson v. Florida Legislative Investigative Committee. What this was just an investigation to the NAACP about whether they about subversive activities, and the court overturned it, stating that there was not enough evidence to connect the NAACP. But it's just what it is mostly the court is trying to find a balance between congressional power and individual rights, and ultimately congressional power wins out most of the time, and now their investigative power is quite just extreme. Now, in terms of separation of powers, this case is not more about keeping one branch from interfering with another. Yes, at the beginning in Kilbourne v. Thompson, it was stated that they cannot investigate affairs that are largely left to the courts and the executive. But what it was mostly just trying to limit Congress's power on what they could do, because the investigative power is one of their biggest powers, and it's one of their most important, and thus the courts would try to limit it, but ultimately it didn't win out. And as seen during Watkins v. United States, it doesn't always work out, and there was a ton of backlash to the branches. And basically, what's happened since then is Congress is free to investigate what they want, can hold witnesses in contempt, and it's very, very powerful. Ultimately, though, when it comes to separation of powers, this was done to limit powers, this was done more to limit the power of one branch, keeping it in balance with the others, as opposed to keeping branches out of each other's business. Ultimately, the investigative power is a very important one, and it will continue to be for years to come. Thank you.